Hi, I'm Shan Wu with the Undercolor of Law analysis of 3 different cases that are going to be dismissed by DOJ. Actually, it's 2, but potential 3rd, particularly interesting. So we're going to talk about them one at a time and take a look for some themes here and what they tell us about the Trump regime's approach to the exercise of their power over prosecutions. Number 1, Walt Nauta and Carlos de Oliveira. Those are Trump's co-defendants in the Mar-a-Lago documents case. Nauta is Trump's longtime personal valet, and de Oliveira is a Mar-a-Lago employee. So Nauta was indicted for obstruction, so was Oliveira, for having helped Trump hide boxes of classified documents or documents involving sensitive national security information. He was actually hiding them from a Trump attorney. It was probably Evan Corcoran, who used to work with me, not for Trump, but we're at the DOJ, who was collecting them in response to a grand jury subpoena. He also then, not Corcoran, but Nauta made false statements to the investigators about it. The other one, de Oliveira, was charged with obstructing justice for having tried to delete security camera footage, as well as having made false statements about helping to move boxes of documents. He actually did personally move boxes of documents, but he told the FBI, quote, "never saw nothing," unquote. Very classic line. Now, I will just share with you for a moment the real sink-in aspect of this kind of obstruction, which really shines a light on the question of what Trump's motives were. I mean, for quite a while, the archivist had been asking for these documents to come back under the Presidential Records Act, and now there's actually a grand jury subpoena. Why would you continue to have people hide the documents? At that point, there was no real risk of criminal indictment. They just want to get the things back. Nauta's hiding them from Trump's own lawyer. Now, you can chalk that up to Trump being stubborn, childish, they're mine, I won't give them back to you. But you also just have to wonder, really, you have to wonder what was he doing with them or planning to do with them that he needed so badly to hang on to them. Now, that's a mystery which we're now likely to never know the answer to. I mean, it seems incredible, but we're probably never going to find out. So recall the case was on appeal over Judge Eileen Cannon, who no doubt has her eye on the next available Supreme Court seat, having reached the historical or ahistorical conclusion that Special Counsel Jack Smith had been unconstitutionally appointed as a special counsel. Presumably, she would have also found that all the previous special counsel had been unconstitutionally appointed as well. So it was a no-brainer at the time for DOJ to want to appeal that, since it's striking at the whole question of whether they can have a special counsel or not. By the way, there's been some form of special counsel since, 19th century, really. Now, Trump was saying that here you can't have one because it's an unconstitutional appointment. And in what world, you got to ask, was Merrick Garland and Smith thinking that once Trump himself was going to be out of the case, what was the point of keeping these two in and continuing to delay matters? More to the point, Garland would not release at least the portion of the special counsel report about Mar-a-Lago because some of it would pertain to 2 co-defendants with live cases. So you're not going to release this report without heavily trying to figure out how to redact it, because these guys are still facing trial. You don't want to prejudice them by just releasing some report about the evidence to the public. But once Trump's case was gone, under some combination of the immunity theory, but more importantly, it was gone because when he got reelected, Justice Department's policy was, we can't prosecute a sitting president. Even though he wasn't president yet, there's no way they're going to get it done before he became president. So they dismissed it. Personally, I don't think I would have done that. I've said before, Jack Smith just kept going until they kicked him out, shut him down. But they dismissed it. Having done that, it was quite obvious that the cases against Nauta and Oliveira were not going to survive. I mean, Trump had said he didn't want to pardon them because it makes them look bad, makes them look guilty. But he didn't have to. As we're seeing, he could just have DOJ dismiss him. So that's what's happened. They've moved to dismiss the appeal, which ends the cases once the court formally agrees to that. And recall also that Judge Cannon had ordered DOJ to not even disclose the report to members of Congress. And that wasn't really necessary at all, because the point was that if Garland had dismissed Nauta and Oliveira, then the charges to begin with would have been moot. There'd been nothing going on them. He could have just released the report at that point. It wouldn't have prejudiced the defendants. There's no case anymore. But no, he didn't do that. They continued this appeal, which was kind of worthless, on this extremely odd decision that Cannon had made. And what was the thinking there? How are they going to possibly get that appeal done before the new DOJ comes in? It was just continuing to tie more and more knots in this whole knot Garland had created. But enough about Judge Garland. The point here is how rare to dismiss a pending criminal case unless something has really drastically changed to cast doubt upon the evidence. Evidence turns out to clear someone, a witness, it turns out they're not credible. Here, the only thing that happened was that the defendant's boss became president of the United States. Again. Next up, case number 2. Representative Jeff Fortenberry. Put up the screenshot about his case. He's a former congressman from the state of Nebraska who took illegal campaign contributions from a foreign businessman. And he got convicted not for the illegal contributions, but for lying to the FBI and scheming to cover it up. It's the usual thing of the cover-up is worse than the crime, right? So he was charged and tried by a jury who found him guilty. But the Ninth Circuit U.S. Court of Appeals overturned it on the grounds that he should not have been tried in Los Angeles, California, as the false statements and the other cover-up didn't occur in California. The contributions happened there. That's where the fundraising apparently occurred, but he wasn't charged with that. The appeals court criticized DOJ, saying that the FBI agents being from the LA office had no bearing upon where the case should have been brought, as the Constitution requires proper venue. The case was reversed and presumably would have been retried since there's nothing wrong with the charges, right? It's literally just so you tried it in the wrong place. Presumably the right place would have been D.C. or maybe the congressman's home state, Nebraska. Now, this is actually very in the weeds, but it's really important to notice. It's a great example of how where you bring the case really does matter. I mean, it doesn't seem that way, like, oh, that's a crime, congressman, why does that matter? Now, that even may have played a role in Jack Smith's original decision to bring the documents case in Florida rather than D.C., where many legal commentators, including me, thought it made sense to just bring it in D.C. They already had a grand jury convened here. They were doing the Jan 6 cases here, but they brought it in Florida because I think they wanted to make sure that the venue was a non-issue, because Trump lives in Florida, and more importantly, the alleged crime occurred in Florida at Mar-a-Lago. So Smith's team took no chances with venue, right? Although they would have had a decent argument to do it in D.C. For their careful thinking about venue to minimize that risk, they were rewarded with Judge Cannon. So hindsight's 2020. Now with Fortenberry, it's critical to remember it's not a pardon, it's a dismissal in a scenario where a jury has already found him guilty beyond a reasonable doubt. Yet Trump's DOJ now dismisses the case. And according to Trump, it's because it was the usual illegal weaponization by the radical left, etc. You can take a look at what his quote said here. And it's really extraordinary, right? Because it's a step up in brute executive power being exercised. It's a step up from the Mar-a-Lago case, because here the jury had actually found the defendant already guilty. I mean, these are people, it's a jury of his peers, beyond reasonable doubt, they found him guilty. Classic technicality, it's not really technicality, it's a constitutional issue, but it's a technicality. He's tried in the wrong place. Why would you now dismiss the case? What has happened? Again, nothing has changed with that evidence that a jury found to be proof beyond a reasonable doubt. Nothing has changed except that Trump won. And in this case, the Justice Department asked the court to dismiss it with prejudice, meaning you could never bring it back. And guess who was the United States attorney asking to dismiss it with prejudice? Soon to be well known to us, we've already talked about him, Ed Martin, the acting U.S. attorney in D.C., likely to become the U.S. attorney. The same man who advocated for J6 defendants, January 6 defendants, and is ordering his own prosecutors to be investigated over their role in bringing the January 6 cases. He's likely to be the next official United States attorney for D.C. Now, still theoretically, that would be up to a judge. And we saw one judge in D.C., Judge Beryl Howell, who refused to dismiss with prejudice cases against violent January 6 defendants. That didn't happen here. They drew Judge Trevor McFadden, a Trump appointee, and Judge McFadden dismissed with prejudice. Brings us to our last case, Mayor Eric Adams in New York. Now, Mayor Adams has been charged, no trial yet, and he has not yet had a case dismissed. He is a man who is swimming in problems right now in terms of political corruption allegations. His top aide, unrelated matters, but was indicted on bribery charges. He faces multiple counts that involve receiving years of free luxury travel, gifts, illegal campaign contributions from foreign nationals, including Turkish interests, allegedly helping Turkey bypass some New York City fire safety standards. He, of course, has maintained his innocence, and he has refused to resign, even though many politicians in that position in the old days would say, this is too much, it's a distraction, I'm going to resign. Now, what we're hearing is reports that his lawyers have been trying to speak with the Justice Department and presumably raising, not presumably, it's being reported that they're raising the possibility of DOJ dismissing the case. Now, let me just say, that in and of itself is not unusual. I mean, I've gone up, they call it going up the ladder, going up the chain on behalf of clients to try and meet with supervisors, go as high as you can possibly get to try and get them to reconsider the question of should your client be indicted, should they be charged. It's very rare, I'll tell you, that going up the chain that way makes a difference if they've already decided to charge. But the mere fact that Adams has his attorneys trying to meet with DOJ about that, that's pretty normal. But the mayor may have some advantages over other high-profile defendants. First of all, he seems to be doing a lot of things to curry favor with President Trump. For example, he dispensed with presiding over the Martin Luther King Day celebration in New York, instead to go attend Trump's inaugural. They have reportedly been speaking frequently over the past weeks. And also, oh, by the way, the head of Adams' legal defense team is also Elon Musk's personal attorney. Now, again, these are not pardons, these are dismissals, and they would be being done at DOJ not by direct Trump directive, I mean, who knows what they're saying, on the quiet, but it theoretically gives plausible deniability, right? Because the president didn't order his DOJ reach that decision themselves. But I question whether they even care about the plausible deniability. Trump's happy to say publicly what he likes, what he thinks is a conspiracy. Now, the one thing to think about is the speed that they're moving at. These are all acting interims. Nominee Pam Bondi is not yet confirmed. Theoretically, this gives them some cover in that it's not the official people taking that decision. So when Bondi becomes Attorney General, which is rather likely, she can say this wasn't done on her watch. But that assumes that the Trump regime actually has some degree of concern over the appearances of impropriety, and that seems really unlikely. So we'll keep an eye on these kinds of actions, and we'll certainly keep an eye on the Mayor Adams case, and we'll keep you posted on it. So thanks again for the replies in the comments. Always good to hear from you, and I will talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.